operating as a subcommittee. First up is Senate Bill 660. Senator McCreery, whenever you're ready.
Good afternoon. Thank you for hearing Senate Bill 660 today. I'm State Senator Tracy McCreery. I represent portions of St. Louis County. I am presenting a bill that's called the Stop Cyberstalking and Harassment Task Force. So this is a bill that I proudly inherited from my predecessor. I have a witness that will share a little bit of the backstory on why we're here today. But there is a lot of data that shows that more and more victims of harassment and stalking are now being both physically harassed and stalked, but also there is a cyber element involved as well, which we all can imagine just because we're online so much more. Right now, according to the Susie Lamplugh Trust, 100% of stalking cases that are reported have some element of cyber stalking involved. And that was just back in 2019, just a few short years ago, only 80% had a cyber element involved. Stalking impacts 1 in 3 women in the United States and 1 in 6 men in the United States. So this bill would simply allow a task force to be created so that we can bring together experts from all around the state of Missouri. So as you can see with how the bill is laid out, we're trying to pull in expertise from both the private sector and the public sector. And ultimately our goal is to make recommendations on what resources and tools are needed to stop cyber stalking and harassment in Missouri. So, and I think there might be some follow-up legislation involved as well where maybe we'll see a need and we could work on that. But I think the first step is gathering information, which is why we're hearing this bill. So thank you.
Any questions for Senator McCreery? Seeing none. Can I get a show of hands how many witnesses in support of the legislation we have? Great. And do we have any witnesses in opposition or for informational purposes? Okay. Go ahead and come forward. Witness in support.
Good afternoon. I didn't expect to be the first one up to bat here. My name's Rebecca Pursley, and I'm one of the victims of Robert Merkel. If you Google him, you can find lots of articles in the media about him, as well as the victims that he targeted across the state and now across the country. The system needs fixing, and the best way to fix the system is to get the experts at the table, look at what's already going on and how we can fix it. In the process of trying to prosecute Mr. Merkel, I found a lot of roadblocks. So that the day that I called the police because his messages had gotten to the point of threatening, and I understood he knew my father's name, and my father might also be a part of whatever his scheme was going to be. I called the police, and the police, so one of the things that stalking does is it can bring the brain into a state of panic, fear, and paralyzation. So I got the officer to my place, and the officer showed me where I could report him online, which was right in front of me, but I couldn't see it. What the officer could not do, or the officer claimed he could not do according to his understanding, was write up a report without the offender's full name. Then it was a year after that that I saw an article that was posted on social media. And I saw a picture of the offender. I saw the story, and I thought, that's the Rob. So one of the things that Robert Merkel does, is he uses aliases. They have included James, David, Rob, I don't know, I forget, there were probably others too, and he uses phone numbers that cannot be tracked. This is a problem. So when I saw it, I was like, oh, now I have his full name. I will contact this person and say, hey, I can validate that this person is no good. I was lucky in that my experience with him taunting me only lasted 24 hours. But I came to find out when I got directed to a detective that multiple women had come with the same claims. Some of them were too afraid to press charges due to retaliation, due to them having children or whatnot. But by that time, he was already locked up, and I chose to press charges. What I've learned is that the victim advocates know more than some of the people at the courthouse. The officers don't know what they have the authority to do. And even the parole officer, once he had finished his sentencing, which could have been 10 years, but because of a plea deal was 3 years, 2 years served. He was out on parole. Women started to experiencing stalking. They knew it was him. They reported to the parole officer, and the parole officer could ask him, did you contact such and such? Are you stalking anybody? And he could say, no. And that was it. His phone could not be looked at. His computer could not be looked at. It was a he said, she said. So he could continue. And it wasn't until a member of Missouri Congress saw the story, reached out to a victim, got the FBI involved, and then more action was able to be taken. There were enough people involved in communicating that they could go to a judge and ask for a search warrant. They got that, they confiscated his phone, his computer, and were able to press charges and learned that he is now he is currently charged with 5 felony charges of interstate crimes, which I don't have the names in front of me, and there's one other charge in the county. And all of this could be avoided if there were stronger laws that would grant him to be locked up longer the first time. He was locked up based on 1 victim in Jefferson County. 5 more victims came forward. The court case happened. For the convenience of the court, they wrapped my case in there and didn't add any time to his sentencing. What that did was tell us, okay, the next crime is going to happen around the time he's released. That's what happened, and now we have courts spending money trying to address this, and at least 6 other women dealing with trauma. So, I think it's a problem that needs to be addressed.
I don't think you'll hear any argument from the committee on that point, that it's an issue that needs to be addressed. And so, any questions for this witness? Thank you for coming forward, and thank you for sharing your testimony with the committee.
Is there anything else I could say?
All right, any other witnesses in support? Seeing none, any witnesses? Oh,
Thank you, Mr. Chairman, members of the committee. Tricia Workman here today on behalf of the Missouri Coalition Against Domestic and Sexual Violence. We appreciate the senator bringing this forward and being at the table. Agree that technology is moving faster than our laws, and this is something that needs to be addressed.
any questions for Tricia? Seeing none, thank you for your testimony. Any further witnesses in support? Seeing none, any witnesses? Ward, are you coming up too?
Oh, no, sorry. No, I apologize.
Okay. Seeing no further witnesses in support, are there any witnesses in opposition? Any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 660. Next up, Senate Bill 480, Senator Thompson Rehder, whenever you're ready.
Thank you, Mr. Chairman and members of the committee. This is a simple bill on fentanyl testing. As we have all heard in the news for over a year now, and certainly very heavy in my area, we have a lot of the opioid deaths that are now due to fentanyl. It's incredibly powerful, and just touching it can be lethal. And so, unfortunately, the words test and analyze are in our paraphernalia sections of statute. And so, in order to have fentanyl testing strips, then you have paraphernalia by our statutes. And so we need these strips to be pulled out of that penalty, and that's what this bill does. Several states have started moving to this to allow, and when it comes to this type of thing, I mean, of course you want to be able to keep someone alive long enough to get them past their addiction, and that takes time, because with addiction you've changed the pathways in your brain, the reward system, and it takes time, and we want to be sure that we're keeping people alive long enough to get them there, and that is what this bill will do. There's going to be some that come up behind me that's going to have a little bit more eloquent way of putting this, and maybe can name off the states that have moved to this type of policy. But with that, I'm happy to answer any questions.
Questions for Senator Thompson Rehder? Seeing none, first witness in support of Senate Bill 480.
Good morning, Mr. Chairman and members of the committee. Thank you for the opportunity to share a few words in support of this important bill. My name is John Hensley. I've been a lawyer in Missouri for the past 16 years, and now also a lobbyist in this building for the past few months, but I'm not sitting here today on behalf of any client or under any contract. Rather, I'm here as just one of a growing and devastating number of Missourians who have lost a friend or loved one to the rising scourge of fentanyl poisoning. In our case, it was a friend from college, a kind, friendly, hilarious, generous, loving, vibrant young man, a successful professional, a committed volunteer and donor to numerous causes that were important to him, though many of us only learned the full scale of his philanthropy during his funeral. My understanding is that he had a valid prescription for a certain medication to relieve severe pain. One evening last August, he found himself in need of one of his pills, and being for some reason without his prescribed supply, acquired a few from an acquaintance. He took one, got ready for bed, went to sleep, and never woke up again. The tragedy of this loss continues to ripple through everyone who knew him, because to know him was truly to love him, and now to miss him. In the midst of the grief surrounding his death, some of us also came to realize that a handful of Missouri statutes make obtaining these test strip kits an absurd ordeal in Missouri, though you can buy them over the counter in 30 or so states around the country. Two of our friends, who are also lawyers, had to go several rounds with and sign numerous sworn statements for a test kit manufacturer, promising that the tests, if sent, would only be used for official purposes. Once they received a box of tests from this manufacturer, they tested the other tablets that had been collected after our friend passed away, all of which were identical in appearance to genuine pills of this type, and all of which showed positive for the presence of fentanyl. Several more tragedies, then, averted by using a simple retail available test that is currently considered illegal paraphernalia in Missouri. I encourage you to change that by supporting Senate Bill 480. In 2022, our fellow Southeastern Conference states of Alabama, South Carolina, and Tennessee became the latest to legislatively permit the manufacture, sale, possession, and use of fentanyl test strip kits. And the approach taken in Senate Bill 480 is very similar to that taken in Tennessee and Alabama. So thank you for your time, attention, consideration, and my deepest, most heartfelt thanks to Senator Thompson Rehder for sponsoring this bill, which, despite consisting of only a single sentence, will finally allow Missourians a simple tool to identify lethal risks, avoid overdoses, and prevent deaths from fentanyl poisoning. So thank you again. I'm not much of an expert on anything, especially not chemistry or pharmaceuticals, but I would be happy to help find answers to any questions that you might have.
Any questions for the witness? Seeing none, thank you for your testimony. Can I get a show of hands? How many more witnesses in support do we have for the legislation? Great. Any witnesses in opposition? Assume not. So for the remaining witnesses, just because we've got so many bills on the agenda, if you could kind of limit your testimony to no more than 2 minutes, that'd be greatly appreciated. Next witness in support.
Chair, members of the committee, Henry Telemock with the Missouri Pharmacy Association, Assisted Recovery Centers of America, Recovered Healthcare, as well as the Recovery House, to go on record as in support of Senator Thompson Rehder's bill. I can't put it as eloquently as John did. The reality is that nearly 1,500 folks are dying per week within the United States on opioid overdoses. Representing Recovered, we work with veterans who have PTSD and suffer from post-traumatic stress disorders. And veterans are 2 times more likely to die of an opioid death than anyone else. By allowing this bill to go through, we're solving many issues. One is allowing healthcare workers to test the medications or the drugs properly without condemning them by saying they're using it illegally, as well as allowing others who may potentially overdose to test the drugs that they receive. We're not allowing or saying, hey, utilize drugs, but we are simply saying we want to not dehumanize those who are struggling with addiction and allowing them to utilize everything that they can to the best of their knowledge.
Any questions for Henry O? Seeing none, thank you for testimony. Further witnesses in support of Senate Bill 480.
Chair, members of the committee, Jessica Petrie here on behalf of the National Association of Social Workers Missouri chapter. Not to reiterate what previous witnesses have said, but these are a life-saving technique, and studies have shown that individuals who have access to fentanyl test strips actually do modify their behavior by potentially discarding a batch or having naloxone on hand or whatever the case may be. And obviously, in an ideal world, right, we wouldn't have anyone misusing drugs. But like the senator said, the real goal is to keep people alive long enough to see them into treatment and into recovery, and this is an important step to do that. So we appreciate her work on this issue.
Any questions for Jessica? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 480.
Mr. Chairman, members of the committee, Rob Monses from the Missouri Hospital Association, here to register our support. We appreciate Senator Thompson Rehder's leadership on this issue once again. We've had several members of the association express an interest in this issue, and substance use disorder is something our members encounter every day, so we'd like to lend our support.
Any questions for Rob? Seeing none, thank you for your testimony. Further witnesses in support of Senate Bill 480. Further witnesses in support. Seeing none, any for informational, or sorry, in opposition? Seeing none, any witnesses for informational purposes? Seeing none, this will conclude the hearing on Senate Bill 480. Next up, Senate Bill 432, Senator Gannon, whenever you're ready.
Good afternoon, Chairman, members of the committee, Senator Elaine Gannon, representing District 3. Thank you for the opportunity to present Senate Bill 432. Senate Bill 432 establishes the Uniform Public Expression Protection Act, which would protect Missourians exercising their First Amendment rights from meritless lawsuits meant to silence them or punish them for their speech. Strategic lawsuits against public participation, known as SLAPP, aimed to punish speakers with costly litigation and censor them. If speakers fight the lawsuit and win, the legal costs still punish them for speaking out and discourage others from speaking. Strong anti-SLAPP laws, such as proposed in Senate Bill 432, are the solution. This bill protects speakers by reducing the incentives to file SLAPPs and enabling defendants to have meritless lawsuits dismissed quickly. While Missouri does have an anti-SLAPP law, it does too little to protect our citizens. Senate Bill 432 strengthens the law's speech protections by addressing our current law's key flaws. First, the bill would expand the scope of speech covered by our laws. Procedural protections to get rid of meritless lawsuits are of no help to a speaker if their speech is not covered. Second, the bill creates a clear right to an interlocutory appeal for an anti-SLAPP motion. That's a legal term that means immediate appeal without waiting for the trial to be completed. Third, Senate Bill 432 requires the plaintiff to show up front that there is a real case that can win. Our current law does not contain this essential feature. Thank you again for this opportunity.
Great. Any questions for Senator Gannon? Seeing none, thank you for your testimony. Witnesses in support of Senate Bill 432.
Thank you, Mr. Chair, members of the committee, Doug Nelson, Clarkston Nelson, on behalf of the Missouri Broadcasters Association in support of the bill. We appreciate the senator bringing it forward. I think the thing that it does that the current law does not do is it allows items to be covered, conversation in hearings, content relating what's been discussed in hearings, and then First Amendment rights. And as related to the First Amendment right issue, on behalf of broadcasters, concerns about running a news story, get challenged on that news story, get a lawsuit, where they then have to decide whether it's better to litigate that or pay a settlement and try to get that issue in front of the circuit judge quicker, have that decision made, and make a decision whether or not it's worth continuing the litigation or resolving it. So, in support.
Any questions for Doug? Just one that I have.
Sure.
We heard a similar bill, I believe, last year. Is it identical to this one?
I believe it is identical, yeah. It's very, very close if it isn't, but I can check that for you.
Thank you. Further witnesses in support?
Mr. Chairman, members of the committee, my name is Doug Cruz. I'm representing the Missouri Press Association today. I want to thank Senator Gannon for her explanation of the bill. And this bill's been in front of you and the House for 3 to 4 years now, and so we just want to echo our support for it. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, Zach Pollock, registered lobbyist with Bunting Parker, on behalf of the Motion Picture Association. Just want to go on record and support the bill.
Any questions for Zach? Seeing none, thank you for your testimony. Further witnesses in support?
Jeremy Cady, State Director for Americans for Prosperity. We just want to go on record and support it as well.
Any questions for Jeremy? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Bill 432. Next up, Senate Bill 616, Senator Black, whenever you're ready.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Rusty Black, and I represent the 12th Senatorial District. Some of you sitting here that know me may wonder, why is he dealing with a bill concerning DMH and public administrators? Just real quickly, 3 basic things before I go into the script on the bill. First, when I became a legislator, there was one county office I had very little understanding or knowledge about, and it was public administrators. And as I visited the 3 counties I represented then, now 19 counties, I've become much more aware of what public administrators' role is within the county and the different things that they're charged with. Even though I had a friend that did that earlier, I didn't understand it. Then I had a new friend elected that I had her students or her children in school, and she makes sure I know what she's doing on a weekly basis and understand some of the things that she has to deal with. Also, Department of Mental Health. The first part of it is we know that they're short of employees, et cetera, all over the place, and this is one tiny little thing that may make a difference with the department, hopefully being able to take care of our citizens in a better way. And as they may or may not say, it's thinking a little bit different now than maybe what I thought of the Department of Mental Health for years and years. And I think they're trying to make a gain to help our citizens. So let's begin. Currently, if a person is charged with a criminal offense, the prosecutor or the defendant's attorney can request a court for an order to have the person evaluated to determine if the defendant is competent to proceed on criminal charge. If the person is found incompetent to proceed on a criminal charge, the person is committed to DMH for competency restoration, and DMH, Department of Mental Health, is responsible for treating the person's mental illness and attempting to restore his or her competency to stand trial or make a determination that the person is permanently incompetent to proceed. If found permanently incompetent to proceed, the criminal charges are dismissed and a guardian is appointed, which is often a public administrator, therefore my friend at home, and must consent to the individual's discharge. Public administrators are predominantly county elected officials who serve as officers of the court, serving substitute decision makers for those deemed incapacitated. And many of them have trouble. You want me to be quiet and go on?
Well, no, Senator, actually, I will ask you to be quiet for just a second, but just so that we can establish a quorum so that way the hearing actually counts on your bill. I don't want to have you come back again next week. If we can
Okay.
avoid that. So, Brad, would you please call the roll?
Senators Lukemeyer,
Here.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. Got a quorum.
We have a quorum. Senator, back
Thank
to you.
you, Senator. And with that last part, that public administrators sometimes in those 19 rural counties aren't necessarily mental health experts. Now, the lady that I know has some background in that, but certainly not all of them. Although guardianship may be suitable in certain situations, public administrators are often not equipped to offer the necessary direct services to help individuals thrive within their community. If suitable community services are not available, it would be unethical and inappropriate for a public administrator to agree to this discharge. Such actions can exacerbate the problems related to the availability of Department of Mental Health hospital beds and may conflict with laws that prioritize the least restrictive options for individuals under guardianship. Additionally, not all persons found permanently incompetent to proceed need a guardian to be successful in the community. Senate Bill 616 proposes the following, and the experts are behind me to help define each and all of these things. Only dangerous felons in first-degree murder, sexual assault, and second-degree rape will require the appointment of a guardian. Person cannot be discharged until Department of Mental Health determines they will not be a danger to others. Guardian must be involved in the discharge process and may request a hearing if they don't consent. Follow-up lifetime monitoring of the person is required, monthly for the initial 36 months, at least once per year. Require notification to the prosecuting attorney at least 30 days in advance. Allows the prosecuting attorney to notify of such discharge to the victim if requested. In part number 7, non-dangerous felonies that do not require the automatic appointment of a guardian, Department of Mental Health can still pursue guardian appointment and cannot be discharged until Department of Mental Health determines the individual will not be a danger to others. specifies that the person or guardian, if appointed, be involved in the discharge planning process. If the person or guardian, if appointed, does not consent to the discharge plan, Department of Mental Health is required to request a hearing before a Department of Mental Health Clinical Due Process Review Committee appointed by the director designee, which can be appealed to the Department of Mental Health director, whose decision will be final. Once discharged, the community follow-up monitoring of the person is required monthly for 36 months, after which the monitor, in consultation with the community treatment provider, can decide to reduce or discontinue monitoring when no longer necessary. Requires notification of the prosecuting attorney at least 30 days in advance. Allows the prosecuting attorney to notify of such discharge to the victim if requested. With that, I'd be happy to answer any questions, but there are individuals from the Department of Mental Health, Public Administrator Association, and Office Prosecution Services also here. I will admit, and remember, I don't think it's embarrassing to be ignorant of things, and this is something that I'm somewhat ignorant, but I'm learning more and more about, and hopefully one day I won't be stupid. Thank you.
That was very thorough testimony, Senator, and well, in terms of my judgment as to your intellect, I don't have any doubts there. I won't speak for the rest of the committee. But any questions for Senator Black? Seeing none, first witness in support. And we are going to ask the witnesses, just because we're running up against a time limit, we still have another House bill to go to just keep your comments as brief as possible.
Good afternoon. My name is Nora Bach, and I am the Director of the Division of Behavioral Health at the Department of Mental Health. I, too, would like to attest that you seem very intelligent, Senator Black, and I thank you for bringing this forward. Senator Black did do a fantabulous job of describing what this statute change is trying to do. I just want to reiterate a few points or expand on a few points. The DMH is working very hard to develop a variety of strategies to mitigate our ever-growing wait list for inpatient competency restoration services. One of these strategies entails making changes to this statute. Once a person is determined to be permanently incompetent to stand trial, they're likely going to be with us for quite a while. We're going to get to know them very well. Some will never leave. However, if someone progresses in the management of their mental illness while in DMH's care, plans can begin for discharge into a less intensive setting. As was said, currently, a guardian must be appointed in all cases and must consent to the individual's discharge. I think we've also talked about public administrators have a limited role in terms of being substitute decision makers, but as the senator said, they are not all mental health professionals, so the type of services that they can deliver to assist the person in the community can be limited. I also want to note that there are a variety of crimes that bring people to us, and these crimes can range from passing bad checks to murder and everything in between. Their permanently incompetent to stand trial status simply means that they are not ever expected to be restored, such that they could understand the charges brought against them or understand the associated legal proceedings. It does not mean that they will be forever inappropriate for discharge because of their mental illness, developmental disability, or cognitive impairments. The phrase successful in the community does not mean their condition is cured. Rather, it means that they can be as successful as any other individual whose mental illness, developmental disability, or cognitive impairment is appropriately managed, but who did not commit crimes. As the senator pointed out, we are adding some language to specify that only dangerous felonies and first-degree murder, sexual assault, and second-degree rape will require the appointment of a guardian. And secondly, we added language that creates a provision of required community monitoring that will be overseen by certified community behavioral health centers. That is something that does not exist today for anyone discharged as permanently incompetent to stand trial. In the course of developing these proposed revisions, the department has met with and communicated extensively with two parties primarily, and those are the Missouri Association of Public Administrators and the Missouri Prosecutors, both of whom I understand may be speaking with you today. The public administrators have recognized the overall benefits of this proposed statutory change. As stated, many of these elected officials have considerable caseloads. One of the results of this change means that fewer will be appointed to their care, and that could lighten some of their loads. A second benefit is that the revised language enables new community monitors to assist these public administrators with individuals other than those who are permanently incompetent to stand trial, but for whom they may need some community services. They can be that resource to them. We have also communicated extensively with the Missouri prosecutors as this language has been developed. I want to take a moment to outline what DMH believes to be their primary concerns, as well as our respective position concerning those issues. As we understand it, prosecutors want to be able to object to the discharge of an individual, and they would want to add required victim notification by DMH when a permanently incompetent to stand trial individual is discharged in the community. This is consistent with what is done when a person is determined not guilty by reason of insanity. With regard to having an opportunity to object to the discharge, this language does include notice be given to the prosecutor at least 30 days prior to discharge. And upon notification, the prosecutor already has the authority under existing law to refile the criminal charges and proceed with prosecution again. If the court is required to determine release, this would further delay discharge and could possibly result in some courts refusing discharge, which then compounds our waiting list problem. Essentially would be counterproductive to the objective we're seeking here. Please let me reassure you that DMH has a robust review process for the discharge of all long-term clients. It includes compiling a packet which contains clinical information regarding their psychiatric stability and readiness for release, proposed location of discharge and aftercare, as well as an integrated risk assessment. And to be approved for discharge, all of that must receive 3 levels of facility administration approval, along with the approval of the Forensic Review Committee. DMH takes very seriously the safety of the public when recommending discharge. Regarding the prosecuting attorney's desire to require victim notification, please note that the language does indicate that the prosecutor could notify the victim of such discharge if requested. Due to HIPAA concerns and DMH as a healthcare provider, we would not be the appropriate party to provide victim notification.
Can I interrupt you there really quick? I just probably need to get to the next witness, but I do have a couple of questions. First of all, I want to make sure that I'm understanding everything correctly. So current law right now, if the bill didn't pass, every time, I'm assuming it's only felony offenses where somebody is not competent to stand trial, or does this apply to misdemeanors as well?
This also applies to misdemeanors.
Okay, so it's very low-level crimes as well.
It can be.
So right now, if somebody commits any type of crime, whether it's a felony or misdemeanor, they are automatically, if they're deemed not competent to stand trial, they're automatically given a guardian.
If they are incompetent to stand trial, we try to treat them and restore them. If we can't do that, then they're permanent.
Then they're given a guardian.
And then they're given a guardian.
And as a matter of practice, just based on the availability of qualified guardians, oftentimes that person happens to be the public administrator.
True.
Which creates a huge burden to them. So the version of the bill that we have in front of us right now would say, as an exception to that, if you commit a non-dangerous offense outside of the categories of dangerous felonies,
right,
misdemeanors, lower level quote-unquote felonies, it would be optional for you to appoint a guardian, but it would still be required if the person was deemed not competent to stand trial. It would be required still for people who committed a dangerous felony.
Correct.
Okay. And then even under current law right now, let's say somebody commits first-degree murder and is charged with first-degree murder and deemed incompetent to stand trial, they could still be released out into the community. Now, I assume that very, very rarely happens. Like it's Hotel California, when that happens, like you can check in, but you're never going to leave.
We remain optimistic, but there are folks who will not leave.
Okay, fair enough. Any further questions for the witness? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support of Senate Bill 660.
Good afternoon, Mr. Chairman, members of the committee. My name is John Killian. I serve as the public administrator in Jackson County, Missouri. I am here on my own behalf and on behalf of the Missouri Association of Public Administrators in support of Senate Bill 616. To our view, this is a positive bill both for public guardians and for the folks charged with nonviolent crimes. First, Senator Luetkemeyer, as you indicated, those folks charged with nonviolent offenses could be diverted away from the guardianship system, provided community-based services, and hopefully succeed in the community. That's good for them because it's hard to get out of guardianship sometimes. At least in my county, we're fairly aggressive in pursuing restoration for our clients that we think are ready for restoration. Even still, it's the rare client that makes it through restoration because we're in the process of disproving their capacity. We're proving that their capacity has been restored for guardianship purposes. So that's a limited number of folks. If we can keep folks out of the guardianship system and on their own, that's better for them. Certainly better for us as well, because it allows us the time and the resources then to devote to those other clients that we have that have need for those resources and services. I would clarify that as a public guardian, we're not so much in the business of providing community-based services. I'm not a social worker. I don't, meet daily with my clients like we would rely on a community-based mental health center perhaps to do, or at least more regularly than I would. But what we do is substitute decision-making and arrange for services and advocate for services. And so the piece of this that provides for community monitoring is absolutely key. Does a couple of things. For those violent offenders that are coming out of the hospital, it allows the guardian then the additional eyes on the client to make sure they're getting the services that they need to succeed in the community. For those clients or those defendants that are charged with nonviolent offenses that come out into the community, it allows them the additional resources to succeed, which is what, in the end, we all want. I will point out one other kind of piece to this that I personally find attractive, and I think it maybe just appeals to my lawyer nature, and that is the administrative review of it. Our current situation is that it's a negotiation, if you will, between the guardian and the hospital staff about when a client is ready for discharge. That's a conversation that happens over a series of years. This bill does provide a more formal review for that process, and it places us in front of a board of experts that is able to provide a recommendation to the department's director, and then if dissatisfied there, of course, we can go to circuit court. But I think what this will do for public guardians is will help mediate against their risk aversion. So with the bill as it's proposed, we'll have these experts between us and the decision that then provides that additional protection that we know the decision to discharge is a solid decision. And so I think that will help us then feel more free to consent to discharges more often. Okay. And with that, I thank you for your time, and we'll welcome any questions you may have.
Great. I have one serious question.
Yes, sir.
Is it true that it's your birthday today?
It is true.
It's your birthday today. Okay. Well, I'll leave it to you to figure out which one of your contract lobbyists outed you to the chairman and whether or not you want to continue that contract into the future.
I appreciate that.
But thank you for your testimony and happy birthday.
Right, thanks, sir.
Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Hello, I'm Ward Cook on behalf of the Missouri prosecutors. Wanted to call on record in support of this bill. We've got some language over in the House that we're trying to navigate, and we're trying to work with DMH on possibly working this into the bill. So far, things have been very, we've been working with them and talking it over. Hopefully we can come to some agreement. We appreciate Senator Black and all of his work on this, and we'll just continue working at it.
I will say, certainly would be the chairman's preference that if there is some disagreement between the department still and the prosecutors, that we'd like to see some resolution of that before we vote out a committee substitute with that agreed upon language. So if you all can continue working and let us know.
Yeah, I think
Let
it
Brad know
was
more appropriately whenever that agreement has been reached.
Sure. I got into this discussion kind of the 11th hour, but it's my understanding that there were 2 trains passing in the night, and they just sort of, cross paths here. It's sort of my understanding. So hopefully we can get it worked out so we don't have contradictions in the statute or any issues, unforeseen issues down the road.
Okay. Any questions for Ward? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in support? Seeing none, any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, Senator Black.
Thank you, Mr. Chairman and committee.
That will conclude the hearing on Senate Bill 616. Next up is House Committee Substitute for House Bills 994, 52, and 984. Representative Parker.
Where for me to go? Okay. Good afternoon, Senator Luetmeyer and committee members. Thank you all for having me. I'm Cameron Bunting Parker. I represent the 150th District, which encompasses Dunklin County, portions of Pemiscot, and portions of Butler County in southeast Missouri. Today I present House Bill 994, which is a bill regarding judicial proceedings relating to 21 statutes and 12 subject matters. So to try to quickly go through those, I was told that brevity is the key thing in the Senate, so I'm going to try to do that quickly. The bill passed out of Committee 13-0. It passed out of the House 157-0. But the 12 subject matters, first of all, it deals with age of adult. This is a change in 455, changing the age from 17 to 18. It was currently 17. It needed to be changed to 18. The second subject matter is guardianships and conservatorships, which deal with Section 475 of the statute. It eliminates the requirement for home studies to grandparents unless requested by a party. Thirdly, the Court Automation Fund, which is dealing with Statute 476, extends the fees collected by the statewide Court Automation Fund to 2029 instead of 2023. These are your CaseNet, your Show Me Courts, your e-file. Fourthly, our bill relates to court reporter salaries, and Section 485 sets the compensation for court reporters commensurate with the level of experience. It actually fixes a problem that was set forth incorrectly in the statute. I believe that Senator Crawford, you all heard her bill, which was Senate Bill 103 that came through your committee, that's very similar to this particular portion of the bill. Fifthly, juror compensation. This bill specifically allows a county to vote to restructure jury compensation for grand jurors or petite jurors. The county pays these jurors, and they can opt in or out of that. Sixthly, the bill deals with disclosure of...
Can I jump in there really
Yes,
quick?
sir.
Just ask, I just kind of had a question mark next to that. So as I understand it, there's a small handful, maybe only one jurisdiction that can opt out of paying grand jurors for the first 2 days
Yes.
of jury service. And what this is seeking to do is to add in Greene County and St. Louis City.
Yeah, that's my understanding,
Okay.
yes.
I mean,
But all of the county, I think the counties can opt in or out. I mean, by statute, they all pay, I think it's $10 per day
Yeah.
by statute.
Okay.
By statute.
I see someone shaking their head back there. So we may
Is that
get a
not-
little bit more
yeah.
clarification on this.
Okay.
It just kind of struck me as odd that we've had in the past attempts in this committee to increase per diem juror pay because it's some embarrassingly low amount.
Right.
And so this seems to be doing kind of at least the way I read it, doing sort of the opposite, which is to pay jurors less money. And so I'm just trying to figure that out.
Yeah, and I'm sure there will be an expert back here that will say that, but my understanding was that it sets the statutory amount is very low. You can, as a county, you can opt in to pay a different amount. It's supposed to save the county money, is my understanding.
Okay, got it.
So, I think I was on number 6, disclosure of personal information, which is Statute 509, which limits the disclosure of confidential or personal
information on court documents and records, your dates of birth, your social security number, your bank accounts. Believe that Senator Trent perhaps had a similar bill that also Senate Bill 72 that came through this committee as well. Seventhly, we have Uniform Interstate Deposition and Discovery Act, which establishes a procedure in Missouri when we get a subpoena from a foreign jurisdiction. It tells the courts and the attorneys how specifically to deal with that subpoena. Eighthly, we have bail consideration, which adds some more provisions to a 544 factors that the judge must consider, the court must consider when assigning or setting bail, the flight risk, whether the defendant poses a danger, his criminal history, his or her failure to appear. Ninthly, the bill deals specifically with tampering with a judicial officer. This statute under 575 creates additional provisions. If a person disseminates personal information of a judicial officer or a family member, their home address, cell number, social security number, this creates additional provisions pursuant to that statute. Tenthly, we have the Public Defender Fund under Section 600. Senator Author has a Senate Bill 245 over here that's very similar to that. Creates a fund for monies given specifically to the Public Defender's Office via grants, donations, bequest. This fund will be controlled by the State Public Defender's Office. And then two amendments to the bill, one dealing with court filing surcharges that extends to the city of St. Louis. And then the last amendment was just a technical fix to statute 485-060 that left out the word and enforcement. So it's just the UCCJEA. It did not have and enforcement in there. So, and with that, if there are any questions.
Any further questions for Representative? Senator Thompson Rehder.
First, welcome. I've not gotten to come down and say hello yet, but it's so nice having another Southeast Missourian female who sounds like me.
Thank you.
But I just wanted to say that I really appreciate the grandparent portion, guardianship portion that you have in here. I personally know two grandparents that the children had to go into foster, which they've already been through a traumatic situation, then pulled from the home. Grandparents are standing there waiting for the babies to be handed to them, and they had to wait to have the full, the background check and the home check before the kids could then make it there. So they ended up staying at a place that they didn't know anything about after seeing mama arrested or daddy arrested. And so I appreciate you having that in your bill. Thank you.
Thank you, Senator.
Any further questions for the representative? Seeing none, witnesses in support. Also, the Missouri Bar and other parties to get to language to close certain pieces of personal information in filings. That's my succinct testimony. Love it. Any questions for Jorgen? Seeing none, thank you for your testimony. Further witnesses in support.
Good afternoon, Chairman Luke Meyer and Patricia Churchill on behalf of the Judicial Conference for the state of Missouri. On the juror compensation, this would change it so that a county could opt in. Right now, it's only Greene County that had a pilot program, and they found that it worked well for them to allow to be able to not pay jurors for the first 2 days of their service and then pay them more for later days. That jurors overall were pleased with that because it is such a low amount that they get reimbursed, that paying them something more if they had to be away from work longer was a bonus for both the county and for the juror. But the Judicial Conference is also here to testify in support, in particular, of the bill in general, but in particular the court automation fee sunset extension, the juror compensation portion, and also the tampering with the judicial officer.
So I know we had this conversation when I believe it was Senator Trent's bill, or maybe also Senator Crawford had one too, about the court automation fee.
Correct.
Has the court had any opportunity to further discuss what I think we should do, which is just to get rid of the sunset altogether?
I think we are certainly supportive of that.
Okay, great. I would expect that will be what comes out of the committee then for the
Great.
committee substitute.
We'd
So
be
I know
happy to
there
see
were-
that.
Okay, great. Any further questions for Patricia? Seeing none, thank you for testimony.
Thank you.
Further witnesses in support?
Mr. Chairman, members of the committee, my name is Brent Hemphill here on behalf of the Coalition of Surety Bond Agents. We want to go on record in the section that deals with 544.453 dealing with bail. This is to try to strengthen and give judges more consideration to flight risk and the crime by which folks are alleged to have occurred. And just want to go on record in support of the bill.
Great. So the bail provisions
Is identical to your 301 that you've passed.
Got it. Any further questions for Mr. Hemphill? Good luck getting it out before you can state your question.
My apologies, Mr. Chairman.
No, you're good. Thank you for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, Eric Jennings, General Counsel for the Missouri Bar. I've noted the positions on several of the provisions in the bill, but the one I do want to focus on is the Court Automation Fund extension in particular, and I won't reiterate what we had said in earlier hearings, but I believe we would generally be in favor of the chairman's approach on that as well.
Any questions for Eric? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chairman, Senators David Clarich appearing on behalf of the circuit judges and the court reporters. Also want to thank Representative Parker for her efforts on behalf of 944. We are in favor of the legislation and would encourage your support and ultimate passage. Thank you very much.
So David, one question I have relates to the court reporter pay.
Yes, sir.
So last year, Senator Huff had a bill on this subject. I thought we passed it through both houses of the General Assembly. Is this some type of clarifying language from
It
that
is.
bill? And can you explain to the committee why that's
I certainly
necessary?
can. It was actually 2 years ago. House Bill 271 was amended by you with a provision that was supposed to compensate Missouri court reporters based upon their years of service. The objective was to not only provide an increase for court reporters, but also to decompress the court reporter salaries. People that had just been successful in passing the examination, which, Mr. Chairman, as you know, only 2% of those who take the court reporter examination can pass it. It's extraordinarily difficult. If you are successful, or if you were successful in passing it, then you would get paid the exact same thing that somebody who had been serving as a court reporter for 35 years would get paid. So the idea was not only to give them a stipend to recognize their years of service, but also decompress those levels. And so that's what the statute in 485.060 did. That's what you passed a couple of years ago. Last year, you're correct, Lincoln Huff, who had the original court reporter legislation, passed the appropriation that would accompany the statutory change that we passed a couple of years ago. After it made itself through the process, after the legislation was passed and the accompanying appropriation was passed as well. What we found was that although we gave a nominal increase to the court reporters, there was absolutely no decompression. So the idea that is before you is nothing other than a clarification of what you already intended to do. In fact, Mr. Chairman, if you take a look at the fiscal note of the legislation that was passed in 271, that's what we thought we were doing. That's probably what you thought you were doing, but that's not what happened. So we're trying to get to that point. Now, I have been working with the court, trying to make an OSCA, trying to make sure that this version will actually work. I think we have it worked out, and I really do appreciate your help.
Great. Thank you for that clarification. Any further questions for David? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses in opposition?
Mr. Chairman, members of the committee, David McCracken here on behalf of the Missouri Creditors Bar. We're only in opposition to one portion of this bill, and that is 488.426. That's the library surcharge. The organization I represent is generally opposed to any sort of court fee increase. Feel like it just adds more and more burden to folks who want to utilize the courts. And I'm happy to answer questions or go into any more detail if you'd like.
Any questions for David? Seeing none, thank you for your testimony.
Thank you.
Further witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on House Bill 994. No further business coming before the committee. I would make a motion that we adjourn. It's been moved and seconded. We are adjourned.